All rise. The Justices of the Appellate Division, Supreme Court, First Department. Hear ye, hear ye. All persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard. Please be seated.
Good afternoon, everyone. Welcome to the Appellate Division, First Department. We have some 4.5 hours of argument time this afternoon. Remember that we have your briefs, we have the record, we're fully familiar with the facts of your case, so ask for the time you need to make your most important arguments. Okay. People versus, forgive me if I don't get this right, Sadaga? Submitted. Shank versus Shea? I beg your pardon? Yes, and the time you'd like?
7 and 3.
7 and 3 and 6. Isaiah H. 5, 2, and 5. Thank you. Dolan versus Daily News. 8, 3, and 10. JD versus the Archdiocese of New York. Do you have, you said you're the appellant. I don't see a respondent. Is there a respondent? Oh, thank you. Okay. You said 10 and 5? Yes. 10 minutes. Thank you. I hope everyone was able to hear me. Okay, good. I'll give you 10 and 2 and 10. People versus Darrell Jones. Submitted. Bremen House versus Lebosco. Submitted. Cassine Sabah Realty versus 125th Street Holding.
Appellant requests 7 and 3 minutes for rebuttal.
Respondent requests 5 minutes.
7, 2, and 5. People versus Sharon Lashley. Submitted. McCabe versus 511 West 232nd Street. 5, 2, and 5. Thank you. 129 McDougall Street versus the Tax Commission.
Good afternoon, Your Honor. Appellant requests 7 and 3.
Good afternoon, Your Honor. Respondent requests
7, 3, and 7. Majuk versus New York County DA's office. I don't believe there's a respondent here. Do you wish to submit? I'll give you 2 minutes. Thank you. Badia versus the City of New York is submitted. First case for argument is Shank versus Shea.
Step up.
May it please the court, my name is Tim McEnany for Appellant NYPD Officer Janine Shank. In 2012, Officer Shank was hit in her patrol car by a box truck which T-boned her vehicle, pinning her inside the vehicle and requiring the ESU to be called in to extract her with the jaws of life.
So we know the facts, and the final assessment after several different reviews was a tie. And in order to break the tie, we would have to find that there was no credible evidence for the basis of the decision. Isn't there some credible evidence to the findings of the medical board here?
Not under the holding of Matter v. Meyer, Your Honor. Under Matter v. Meyer, it's required that the medical board actually articulate the factual basis for their conclusions. In this case, there is no rationale supplied at all. They simply denied accidental disability retirement pension without saying, the medical board does not say that the surgery was not necessary. The medical board does not say that the surgery was unrelated to her line of duty injury to the very same area she had operated on, which was her neck.
I don't think they have to explain the cause of the medical condition, but they do make a recommendation with regard to whether it was disabling. And they indicate that in the previous medical reviews, they found that she was not disabled.
That's true, Your Honor. That was earlier in the case while she was still receiving conservative treatment. So she went through about 7 years of conservative treatment, all of which, by the way, was authorized by the...
Don't they find that the petitioner's condition is not related to the March 3rd, 2012 crash?
They actually don't, Judge. There's no verbiage to that effect anywhere in their report. It has to be surmised or speculated upon, and counsel for the respondents does that, but that's not counsel's place. That's the medical board's obligation, and that deprived my client of a full and fair administrative process for her application because she was not confronted with the reasons that she was denied. Had she been, she would have had the opportunity to adduce new evidence, additional evidence to satisfy those objections. When they're silent as to what those objections really are, and they give no rationale at all, this court doesn't even have a record it can actually review. And the court cannot substitute its own judgment for that of the medical board in terms of their rationale for denying an application. They must provide it. If they do not, at minimum, a remand is required.
Didn't they indicate, however, that the condition became disabling only after the surgery?
Yes, Your Honor.
They clearly indicated before that it wasn't disabling, and then afterwards it became so.
That is true, Your Honor, but when treatment that arises directly from a line-of-duty injury results in disability, that line-of-duty injury is the cause of that disability. If the treatment itself is disabling, this is true of various types of narcotics that certain officers have to take after they have accidents and they have pain, and that is disabling to them. They receive three-quarter disability pensions, so should Officer Shank. Her surgery was disabling, but it was necessitated by her injury to her neck. And it's important to note that in the record it shows...
There were some doctors that had, contrary to her doctor, had opined that surgery was not necessary.
I never finished my point before, but that is because this was early on. This was soon after the accident took place, within a couple of years thereafter, while she was still pursuing conservative treatment. Orthopedic surgeons, neurosurgeons do not recommend surgery until you've tried conservative treatment first. They'll always say, you're not a candidate yet, you need to try these things. This was the case with Ms. Shank. And her surgery was authorized by the medical division's own doctors. These are NYPD doctors who said, yeah, we see the connection between your 2012 line-of-duty injury and the necessity of this surgery. That's why we're paying for it. That's the only time the medical division authorizes a surgery, is when they believe it's directly related to the line-of-duty injury. Every single authorization puts the date, March 3, 2012, the date of her line-of-duty injury, as the injury that this treatment is pursuant to, including her surgery. So all the way through the case, it's consistent. Through all of her treatment, she's authorized over and over again based on this line-of-duty injury where she was hit in this patrol car. So this is through no fault of her own. She's getting all the treatment she's supposed to get. She requests authorization from the medical division. They give it to her because they believe it is related. And then the medical board for the pension fund says, okay, they say that this was medically necessary for you, that it was related to the line-of-duty injury. We're denying you a pension.
Isn't the fact that she was able, and they found that she was able to go back to work full-time and that she was able to perform all of her police duties, wasn't that the basis of their saying that she wasn't disabled by the accident?
No, but it's close to what they want you to think, Judge. They don't actually say that. What they say is she went back to full-time work at a sedentary position. She didn't go back to full duty. She's not out in the streets restraining emotionally disturbed persons or wrestling people to the ground to put them in handcuffs or push them into a police car. She was completely incapable of doing that at the time, which is why she was restricted in that position.
Well, aren't there officers who are assigned to that position?
Assigned to which position, Judge?
The position that she was in when she served out her 20 years.
There are, but the requirement for a three-quarter disability pension is only that you show that the officer cannot perform all the essential functions of her job title. That includes arresting people. That includes standing parade duty. That includes being outside in all kinds of weather and not being able to be relieved. That includes working extra shifts. That includes being sent out to the street for any reason at any time. She has no guarantee she could sit behind a desk. She was in an area where she was able to do that, but that doesn't mean that she is capable of being a full-duty police officer. She clearly isn't. She can't perform any of the 11 essential functions of a police officer with her condition. They knew that. The fact that she was able to sit at a desk.
Did the medical board find that, that their examination of the petitioner, that her subjective complaints did not match the objective medical findings? Didn't they expressly come to that conclusion?
They did at certain points in the distant past before her operation. Yes, they did. But not in any way related to their final conclusion that she doesn't deserve a 3/4 accidental disability retirement pension. It's never mentioned.
Thank you.
Good afternoon, Your Honors.
Good afternoon. Can you direct us to where specifically the medical board speaks to her disability and the reasons for the disability?
Absolutely, Your Honor. So I think that if you look at the final report is the sole report that the medical board concludes that she is disabled. And if you look at the report, it actually incorporates all of the previous reports that all found that there was no disability, that this accident did not cause a disability. When they get to the actual disability, they give a specific diagnosis, and that is that it's a cervical spine derangement status post 2-level fusion. And so I submit that that is an explicit reference to what the actual cause of the disability was in the medical board's view, that they specifically referenced the spinal surgery as the cause.
What was in the previous, as you say, they incorporate all of the previous reviews. What were the reviews previously that indicated that the accident was not the cause of her injuries?
So I think that there's, I think the petitioner blurs the line a little bit here with regard to but-for causation and proximate causation. I think it's important to keep in mind that the higher standard in the administrative code is what applies here, proximate causation. And I think that in each of the prior reviews, the 5 prior reviews over the course of 7 years, the medical board found that through its own examination of the records, its own examination of the petitioner, and its own interviews of her, that the objective evidence essentially did not support her subjective complaints with regard to her injuries. It's not a question of whether she had suffered any injuries whatsoever in terms of the accident. We don't dispute that she received medical treatment following the 2012 car accident. The question is whether that accident led to the actual disability here. And I submit that what we have here is significant evidence that supports the view that the surgery was actually an intervening cause, severing the proximate chain of causation to the original accident. And I think that that's borne out by the long history of the medical board reviewing her condition and finding no disability. Now, petitioner identifies a number of other opinions in the record, opinions with regard from the NYP Medical Division, but those are not binding on the medical board or the pension fund. The medical board is entitled to rely on its own expertise by reviewing it, and in here, it reviewed the records itself, it interviewed the petitioner itself, and it also examined her itself and found that until the surgery, she had full range of motion, that the objective evidence did not support her subjective complaints of pain that she says prevented her from performing her duties.
You're saying they did their own physical examination?
Yes, they did, Your Honor.
So what's your response to what petitioner's counsel says that, yes, she was assigned for all those years, I think she was assigned to some sort of warehouse duty, perhaps, so that, yes, she was on the job, but she wasn't capable of doing the things that one would normally expect a police officer to be able to do?
A couple of points, Your Honor. I think that, number one, there is ample evidence in the record that this was full duty, that both the medical board as well as the NYPD's doctors returned her to full duty after, especially after the initial round of 2014 reviews. There were 3 reviews, and then she returned to full duty. Now, she characterizes the duties that she performed as, only sedentary. She wasn't going out and, arresting folks and things like that, it seems like. But number one, that is still full duty as a police officer, and I don't think that there is anything in the record to suggest that officers that perform those duties are all disabled or they cannot perform their duties fully. And number two, I think even accepting a view that this was somehow indicative of her actual condition, at best, it is a differing medical opinion by the medical division of the NYPD or her supervising officers to place her in the quartermaster role. The medical board each time, 5 times, found that she was able to return to full duty, complete full duty, not just sedentary duty, not just duty in the quartermaster section, and found that her complaints that maybe her superiors believed that she would be better off in the quartermaster section, but that is not binding on the medical division. The medical division, or the medical board, pardon me. The medical board is allowed to come to its own conclusions here.
So we shouldn't then place any weight on the fact that they paid for a surgery.
I think that is a fact that the medical board and the pension fund are allowed to consider in the whole context of this case, the totality of the circumstances, to determine what the actual cause was, what the proximate cause was, pardon me, of the disability at the end of the day. But I think that it is. I think that given all of the other evidence in the record, the credible evidence showing that this was an intervening cause, that it wasn't until the surgery that there was any disability.
The medical board's finding that the surgery was not required based on the line of duty injury?
I think that that's fair. I think that when you read the report that the medical board issued, it found that the disability was attributable to the spinal surgery, and we know that because of the actual diagnosis that it gave. And it also described how the only change was this intervening cause, the surgery that occurred. The medical board actually reviewed her condition just a couple months before.
The intervening cause if the surgery is deemed not to have been necessary, not to have been needed by the line of duty injury, correct?
I think that's fair. I think that's in general. I think that I think that's a fair reading of the medical reports here. That's the conclusion that the medical board reached, and I think that it would just elevate form over function to require the medical board to do anything more than it already did in this case by referencing its prior reviews as well as identifying the actual cause that it believed the proximate cause of the.
Time is up very quickly. How is the determination to pay for her surgery made?
How is the determination?
Pay for the surgery.
I believe that it's the NYPD medical division that assesses the connection to whether it's is.
So it's
whether
not the
compensation is
medical
required.
board that's making that.
The medical board is not making that, so they serve entirely different roles.
And their doctors are completely unrelated?
Their doctors are completely unrelated. The medical board is a set of 3 independent doctors that they conduct an impartial review, essentially, of the medical evidence, and in this case, they conducted their own examinations, Your Honor.
Any further questions? Thank you.
Thank you, Your Honor.
Just like to point out, the court did ask my opponent where specifically the medical board said these things and could not point it out. He's asking the court to intuit this from prior reports. We have no idea what the medical board's rationale was because they didn't provide it.
Well, I thought he said that their current report specifically incorporates what they've said before.
So the court,
wrong?
so the court is required to sift through 60 pages worth of densely worded medical documentation to find out what of all the things they said were the reason they denied this person's pension application. They're required to succinctly and clearly state it when they deny it. In that report, it's part of the NYPD's own rules. The pension fund's own rules state you have to clearly and succinctly say why when you deny. That's it. They didn't do it. At minimum, a remand, Your Honors. Thank you.
Thank you both. Isaiah H.
Good afternoon. May it please the court, Rebecca Viscatas for the presentment agency. The family court erroneously dismissed these juvenile delinquency proceedings, which were timely filed under the COVID-19 tolling provisions. This court and every other appellate division have now held repeatedly that Executive Order 202.8 and its successors told statutory filing deadlines rather than suspending them.
Is it your position that from the time we should take the period remaining in the period up to the time Isaiah would have turned 18 and then tack that on after the executive order was lifted?
Exactly, Your Honor. That it's well settled that that is how a toll functions, and here the operative deadline was Isaiah's 18th birthday, so that is exactly how the toll should have been applied, and the toll affected the statutory filing deadline for the juvenile delinquency petitions. The fact that the statutory deadline in place here was tied to a fixed date, being a juvenile's birthday, did not mean that it could not be tolled. The executive orders did not have any carve-out for juvenile delinquency cases. They specifically said that they applied to the Family Court Act deadlines, and the statute of limitations for delinquency proceedings, contrary to Isaiah's argument, is not a jurisdictional requirement. It's clear from the Family Court Act's plain language that this is a statute of limitations and that the limit on the family court's jurisdiction is a juvenile's age at the time of the alleged commission of an offense, not the time of the filing of a petition. In addition, rescinding the emergency orders, contrary to the family court's determination, it simply ended the tolling period. This is really the only reading that makes sense here, because under the family court's reading, instead the toll was essentially suddenly converted into a suspension. And by that point, the widely prevailing view was that the toll had, in fact, been a toll. Even outside of the juvenile delinquency context, countless civil litigants were still relying on it. Countless litigants are still relying on it today. And this would have been, completely undoing this toll would have been a sudden and significant shift with a practical effect of depriving a large number of parties of the ability to commence an action. And there's just no intention, there's no indication that that's what the governor intended to do by issuing a broad order rescinding all of the COVID-19 directives that were still in effect well beyond just the toll of statutory filing deadlines. If the court has no further questions, I'm happy to address anything on rebuttal, but this court should reverse the family court's order and find that the petitions were timely filed.
Thank you.
Good afternoon, Your Honors. I'm Marcia Egger for the respondent in this case. The failure to take into account the executive order issued June 24th, 2021, effective June 25th, 2021, that rescinded all the remaining.
Isn't it a tolling? Doesn't it stop?
It's not comparable to tolling. And in fact, I want to explain that the family court and the presentment agency, as far as I know, throughout the city, were doing this. This is how they were handling these cases.
So, counsel, may I ask you, though, please? I mean, haven't we all, including this department, like 2 months, hasn't every department, including this department, 2 months ago said, no, 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 whatever you were thinking, here's what it is. It's a toll.
But this is not the same for the Family Court Act.
It doesn't matter. I mean, we have interpreted the executive order. Why should we've done it on the appellate level in the first department. And so is the second department, so is the third and the fourth department.
These were not family court cases.
Why does that make us?
Because the Family Court Act, that is contrary to the city's contention, Family Court Act 302.2 is a jurisdictional statute. It doesn't equate to statutes of limitations that allow notice of appeal or criminal cases to be deferred. It does not provide, 302.2 does not provide a room to have the...
Are you saying that there can never be a toll under the Family Court Act, ever?
We don't even need to get to that issue.
Well, isn't that what you just said, though?
No, because 210 this case arose after 8-210 was issued.
Right,
in
I
which-
mean, but
and
we've
it's
already,
rescinded.
again, we're not ignoring 4 department cases that indicate this is how we're going to interpret it. So let's assume that we're going to stick with what every single department has said, that this actually is a toll. So then I'm trying to figure out why doesn't the toll, you're saying the toll doesn't apply to the family court because it's jurisdictional and not, and because it doesn't apply to
It's,
statute of limitations, but aren't all statute of limitations in that way jurisdictional?
not the way the family court is a court of limited jurisdiction. It only has the powers that the legislature permits. And it does not have the authority to adjudicate a juvenile delinquency petition filed after someone turns 18. And that's exactly what happened here. And the way the family courts were, with the presentment agencies, were operating, they had the presentment agency, even prior to 210 and prior to any of the rescission, would make motions in the family court to be able to file despite the existence of the executive orders. And they were given permission to file, and they did file, and they would ask for these special permission when somebody, that one of the instances was when a respondent, a potential respondent, was about to turn 18 or had turned 18. And they then had the ability to file whenever that permission was granted. With this
But that was at a time before the first department, second department, third department, and fourth department interpreted what happened under those executive
I'm not sure
orders,
that
right?
that they would be with all of them, because I know there's Brash,
Right.
but
So
I'm saying those were all
requests were
the two-
before that, before the department said, no, this isn't something else, this is a toll. So presumably,
toll cannot-
after the appellate court tells the family court, this is how we're interpreting that, these executive orders, that they would find that they didn't need anymore to ask for that permission.
This puts the whole import of 210 and of the Family Court Act's 302.2 into a bizarre torturing of what is supposed to happen. The Family Court Act does limit what the family court can adjudicate pursuant to, in this instance, the Article 3, 302.2. And that is not something that can be halted or rearranged for the purpose of allowing the filing of a juvenile delinquency petition well beyond the 18th birthday.
Well, you say well beyond, you're saying at all. You're saying
Well,
at
yeah,
all. If it
I
was
am
the
not-
day after, would that,
Sorry?
because if it was one day, would that make a difference to you?
No, it would not. The 18th birthday is set.
I just wanted to clarify because of the.
But it's not, in this case, other cases where 210 had not been issued, it was interpreted that they had up till the point that the permission was granted prior to 210 to file the petition. And the corporation councils in all the boroughs were getting permission and filing these petitions based on the imminence of the 18th birthday, and for other reasons, but those were one category. And once...
But let me ask you this, wouldn't that also cut the other way? Wouldn't that also deprive someone who might benefit from a family court treatment of their case from getting that treatment simply because a pandemic occurred? So that's what I'm saying.
Well, excuse me, I'm sorry, we're not
No,
finished.
I'm saying.
Family Court Act also puts a limit on the age of, in Article 10, for child protective, and the same could be said of the once a child reaches 18, they could not file a,
But maybe they might want to, maybe they want,
Well,
maybe
they-
they might want to take advantage of that,
They're-
right? And they
the
got stuck
legislature-
without it. Well, so that's what I'm saying. So they're stuck not being able to take advantage of the family court because of a pandemic that they had no control over, and the governor specifically said all these.
Okay,
period
but
shouldn't
there was not this dispensation given in Article 10. And in Article 3 cases, the juvenile delinquency cases, they could file, if they got permission, if they asked for permission, to file as an exception to the policy of the executive order that said only extraordinary cases with extraordinary circumstances qualify.
It's okay.
So, but I think you can't ignore that the Family Court Act's jurisdictional prescription.
Thank you.
I will just note briefly on the jurisdictional issue that really the Family Court Act could not be clearer. Section 302.2 is a statute of limitations. Section 302.1 clearly states, in determining the jurisdiction of the court, the age of such person at the time the delinquent act allegedly was committed is controlling. It's clear that that is the jurisdictional limitation, and the statute of limitations is a statute of limitations.
Time of the act and not at the time of the filing of a petition.
Exactly right, Your Honor. I'm happy to answer any other questions. Otherwise, we ask this court to reverse. Thank you.
Thank you both. Thank you. Golan versus Daily News.
Good afternoon. May it please the court. My name is Richard Altman. I'm here for the appellant Yuval Golan. In the normal defamation case brought by a private party, the threshold issue on a motion to dismiss is, generally speaking, an examination of the language to determine whether it's susceptible of a defamatory connotation, and whether, if there's any privileges that might apply, whether they're sufficient to bar the action altogether. But we're looking now at the anti-SLAPP amendments, and they have changed the landscape completely.
If we were to determine that the article was not defamatory, Supreme Court came to the conclusion that the appellant should pay attorney's fees. Why shouldn't attorney's fees be paid under the anti-SLAPP?
Why should the attorneys?
Why shouldn't they be paid?
Why shouldn't they?
Why was Supreme Court wrong in imposing attorney's fees here?
Because the statute and the predecessor statutes call for attorney's fees to be recoverable only by a claim, and they hold that a motion to dismiss is not a claim. Had the legislature wanted to make it possible for a person to obtain fees under that circumstances, they could have said, you can obtain them by part of a motion to dismiss. They didn't say that, and predecessor statutes, which have the exact same language, also made the same holding that a motion is not a pleading. Second of all—
There was an amendment in 2020, wasn't there?
I beg your pardon, Your Honor.
Wasn't the statute amended in 2020?
November of 2020, yes.
Did that amendment affect what you've just said?
I don't believe it did, because the language is the same, and there are cases cited in my brief in which lower courts have denied requests for attorney's fees precisely because the defendant did not—
So what you're saying is that the statute does not authorize attorney's fees where the defendant makes a motion to dismiss pursuant to 3211, there has to be an affirmative, whether a counterclaim or a standalone claim for attorney's fees.
That is my position. That is the position of several lower court cases which have so held. There is authority to the contrary, yes, there is. But I think the rule, based upon the language of the statute and the interpretation of the previous statute, holds as what I just said, which is that a motion is not sufficient. Furthermore, there's something, this is not a fee-shifting statute.
So then, counsel, so that would mean that one could never make a motion to dismiss and get attorney's fees under, one would always have to wait for summary judgment, right?
No, if a motion to dismiss would be granted, then by definition, the defendant has prevailed, and presumably a claim could be brought.
So wait.
Or a counterclaim could be brought in the action.
So you're, right, exactly. So I'm saying your position is that the defendant must answer the complaint, that there's no possibility of cutting off the claim pre-answer.
A defendant could bring a separate action.
Right, I'm saying more litigation. You're saying there must be more litigation. There can't, we can't resolve this in one pre-answer motion. They have to either bring a counterclaim or you have to bring a separate lawsuit. There must be more litigation to resolve the SLAPP, the anti-SLAPP legal fees issue.
I think that's correct.
And that's not generally true and that's not, I'm sorry, let me just finish my question. You were answering and I interrupted you, I'm sorry.
No,
and I'm saying that generally isn't true in fee-shifting statutes. You don't have to bring a new claim.
This is not a fee-shifting statute. It doesn't provide fees to the prevailing party. If my client wins the litigation.
You're relying on, are you not, on Civil Rights Law Section 70A, right?
Yes.
Is that what you're relying on, which says a defendant in an action involving public petition and participation, as defined in paragraph A of subdivision 1 of Section 76 of this article, may maintain an action, claim, cross-claim, or counterclaim to recover damages, including costs and attorney's fees. It's your position that this statutory language on its face does not authorize the award of attorney's fees upon a dismissal motion. You would have to have, in fact, answered and put in a counterclaim and then move to dismiss.
That is what
summary judgment.
That is what the plain language of the statute says, and that is what prior cases have held. And current cases under the new law have also held that a defendant must file a claim, and say several lower courts, we're not granting attorney's fees because they cannot be granted a motion. Second of all, it's not a true fee-shifting statute for the simple reason that a plaintiff who wins doesn't get to recover his legal fees. So there's something very off about this, and the intent of the legislature was maybe to prevent frivolous suits under the prior law. But what we have here now is a sudden shift, where now suddenly, instead of an individual being protected against a crushing defamation suit from a large corporation, it has now been interpreted to prevent a private person, my client, from seeking judgment that he has been defamed. Now, the statute, as I argued in my brief, the highest courts of 3 separate states have ruled that statutes like this, which require the trial judge to make an initial threshold determination, violate the plaintiff's right to a trial by jury, because they require a threshold determination which can throw the plaintiff out of court.
That issue is not preserved here, is it?
It is not preserved, but I believe respectfully that the court has the power to entertain it, and given the importance of it and the fact that we're talking about 3 other Supreme Court, the highest courts of 3 other states, there is something not quite correct here and potentially unconstitutional. The court can reach it if it chooses. But let me get to some of the merits of my other argument with respect to this case. First of all,
Well, your time is up. I'll give you another minute because I did give you all the time you asked for. So why don't you go ahead and then you can continue on rebuttal.
the question of whether Civil Rights Law 74 applies in this case should be a factual one because there is material which is outside the court records, number one. Number two, the court records are not summarized accurately and correctly. There has to be there's some room for interpretation of what a court may have said to be protected by the statute, but this case, the facts in the article went far beyond it. There are statements included by people who have nothing to do with the litigation, who were just put in there to smear my client.
If we find that there is, that what you're saying about those allegations are not born in the, that the author of this is protected because there's a factual basis for it, would that impact your statements about the attorney's fees at all?
Could you please rephrase your
I'm
question?
saying, if we disagree with you about your substantive claims with regard to the anti-SLAPP, would that change your opinion about the attorney's fees?
Well, then the question would be moot because the case would not be dismissed and therefore there would be no entitlement to attorney's fees anyway. So if the case goes forward, there's no legal fees. It's only when when there's a dismissal or a judgment on the merits of the case.
I don't think you understood Judge Renwick's question. If we if we disagree with you, if we find that it's not defamatory, does that affect what you're saying about the attorney's fees?
Yes.
In other words, if you affirm the dismissal?
Right. That would be my
dismissal,
disagreeing with you, yes.
If you affirm the dismissal, then my position is still that attorney's fees are not awardable in the context of this litigation. That's what the statute said, and that's what predecessor statutes say. I just want to say one or two words about the defamation by implication here and the defamatory nature of the headlines. To call somebody a land shark when all that's talking about is some real estate deals that he made, that's an accusation of criminality.
But there is no allegation of criminality within the article. I think there is actually a statement that there were no criminal charges brought.
That is correct. That is correct. But a headline can be defamatory all on its own, irrespective of what the context.
Except there are different ways of looking at that very headline, and one of the ways is that it's not defamatory at all, that it doesn't inure to criminality.
I would say that the phrase land shark certainly implies a degree of criminality. It's close to loan shark. It implies someone who's an exploiter, who scammed people. I think it's perfectly reasonable, let us say, and ultimately whether it is defamatory or not should be a jury question, whether the phrase loan shark and the subheadlines.
There's no loan shark, not loan shark.
I beg your pardon.
Yeah, there's a big difference because it doesn't say loan shark.
Indeed there is. Indeed there is. But I think the threshold issue when a motion to dismiss like this is the phrase land shark potentially capable of a defamatory connotation? And I think it is. And because of the whole subtext of the article clearly implies that the man is a criminal, regardless of what the fact that someone was quoted as saying he's not a criminal. The fact clearly implies, as the Davis case and the case of the Supreme Court justice that this court decided, the article clearly intends the implication that the man is a criminal, and that is sufficient regardless of the facts in the article. So, thank you.
Good afternoon. May it please the court. Matthew Leash for the respondents, Daily News LP, and Noah Goldberg. I'd like to just briefly touch on the constitutional issue here. It is not
The
preserved.
phrase public petition and participation is a key phrase in our consideration of this issue, right?
Yes, Your Honor.
So Civil Rights Law, Section 76A, Subdivision 1A says, an action involving public petition and participation is an action claim, cross-claim or counterclaim for damages that is brought by a public applicant or permittee and is materially related to any efforts of the defendant to report on, comment on, rule on, challenge, or oppose such application and permission. Subdivision B goes on to say that public applicant or permittee shall mean any person who has applied for or obtained a permit, zoning change, lease, license, certificate, or other entitlement for use or permission to act from any governmental body or any person with an interest, connection, or affiliation with such person that is materially related to such application or permission. Those provisions are applicable to what we're discussing, right? So my question is, if that applies to what we have here, how does the plaintiff fall into those definitions so as to make you eligible to get legal fees when the plaintiff brings a defamation action against you? Doesn't the plaintiff have to fit into one of those categories of seeking a zoning change, a lease, a license, a certificate? He engaged in a real estate deal. This didn't involve government action, only insofar as that everything may involve the government.
Your Honor, the language that
Sorry for the long question.
Oh, no, that's fine. The language you're quoting is the prior pre-amendment version of the statute. It was the definition of an action involving public petition and participation used to be very limited in the way that you've just quoted. But that language was amended in 2020, and the current language is much, much broader. I don't know if I have it in front of me. It's quoted in our brief. But it's essentially anything involving a matter of public concern, and now is the way it's defined. They've eliminated that restriction to only being based on applications for permits. And it's been interpreted broadly. The statute itself says that language must be interpreted broadly. So I don't think there's any real dispute here that...
How does the new broader language, would Supreme Court err in awarding attorney's fees?
No, I don't believe so, Your Honor. So the issue here is the language in the fee provision talks about bringing in a claim, cross-claim, or action for fees. And my esteemed counsel is arguing that that means it has to be a literal claim or counterclaim. It can't be via a motion. And there is some authority under the pre-amendment version of the statute saying that that's correct. However, the legislature, when they amended the statute in 2020, made some fairly significant changes. One is that in Section 76A, which defines an action involving public participation, they added a definition of the word claim. And this new definition of claim says that a claim includes not only a claim or counterclaim or action, but any filing requesting relief. So that clearly includes a motion. Now that's 76A, that language is not specifically included in the fee provision, but it's all part of the same statutory scheme, and we think it would be illogical to read the same phrase, claim, as meaning two different things in two different parts of the statute. And this court considered this issue, at least indirectly, last year in the aristocrat plastic surgery case, and that was a case where the the defendant below had sought to dismiss and ask for fees via a motion. The court granted the motion to dismiss but denied fees. It came up to this court, and this court remanded and said to the lower court, reinstate the request for fees. The only request for fees in that case was via motion. So at least implicitly, this court was saying that's a sufficient way to seek fees under the anti-SLAPP statute. There was no counterclaim or claim in that case. It was only a motion seeking dismissal and fees.
So let me ask you this: if someone found that if the trial court had found that the statements weren't defamatory, regardless of the fair reporter privilege, would you still say that you could get attorney's fees under the anti-SLAPP statute just for asking them?
If the court found that statements were not defamatory?
Right, without reference to the reportage privilege.
Absolutely, because the standard in the statute...
So how could you make that determination on a pre-answer motion to dismiss that this was... So essentially what you would have to do is you would have to prove that it was part of public participation, which you wouldn't have the cloak of the civil rights law, so I'm struggling with that. If this was just a straight up, you know what, these statements they were substantially true, they weren't defamatory, you win. and without reference to the civil rights law, you're saying you could still get attorney's fees under anti-SLAPP, but the judge would have to find that this was public participation, right?
Yes.
Which is, isn't that a fact? I mean, if you're cloaked with the civil rights law because it's a newspaper article about something of public interest, that's one thing. But if you're just doing it on a straight defamation, doesn't the court have to make a factual finding on a pre-answer motion to dismiss as to whether or not this qualifies as public participation, even if it's not covered by the civil rights statute?
I don't believe that that's actually a factual determination for purposes of the statute. The 76A says that if the claim in question is an action involving participation, then the plaintiff has to satisfy these criteria to survive dismissal. And it defines an action involving public participation very broadly. It's essentially any matter involving an issue of public concern. And there's ample case law from the Court of Appeals and this court and other courts explaining what is an issue involving a matter of public concern. It's anything that's a matter of public interest. It might not be, for an example, if somebody writes a letter to a friend complaining about a third person.
Or, I mean, there are plenty of online things that people say about each other that might not be of public participation. I think what I'm, because you're lucky, because this is a newspaper article which is covered under the civil rights law, and you get this sort of patina of course it's public participation, but if it's not, and in fact, I think that's part of the reason why the law was amended, because everybody was suing for Yelp reviews.
Yes.
How does the court make that factual determination on a that this is public participation?
Yeah.
On a pre-answer motion to dismiss, sufficient to award attorney's fees?
So the first answer is the statute itself, 76A. And again, I don't have this provision in front of me because it wasn't at issue in appellant's brief, so we didn't brief it. But I will tell you, the provision of 76A says specifically that a matter involving public concern shall mean anything other than a purely private matter, I think is.
I mean, okay, so, so then doesn't the trial judge have to say, gee, someone writing on Yelp that my neighbor's dog poops all over the neighborhood, is that public because it involves the neighborhood, or is it private because it's just between me and my neighbor and the dog poop, on a pre-answer motion to dismiss?
I would say that, while that might be a close issue, I don't think this is. This is a report of a real estate
That is my issue.
who,
Are we deciding this because of the civil rights law, because it's covered with this, the attorney's fee issue, because of the patina of this is a newspaper report on something of public, and it gives it much more oomph to say, of course it's public participation, and therefore, yes, you can get your attorney's fees?
Your Honor, I don't believe that it's a distinction here that really affects the fee issue. I think here, regardless of whether there's a line between what's public and what's private, this is so far on the public side of it, with 8 court decisions, with findings by courts about what appellant has done here, clearly a matter of public concern.
What you're saying is that any decision here we make just would be narrowed to this particular set of facts.
Well, I believe the courts have already addressed this, and many courts have looked at what's a matter of public concern. This is routinely decided on motions to dismiss, but regardless of whether any of the judges on this panel have concerns about that approach, I don't think it affects the outcome here, because the facts here are so clear.
But in the defamation context involving a newspaper, you take this case, suppose we agree with you that it's not defamatory, but the claim to say that it's defamatory it's not a frivolous claim. So someone who wants to challenge that is sort of automatically left in a situation whereas if they're going to lose that, they're paying attorney's fees?
That is the policy choice the legislature has made. The legislature has said you can get a claim dismissed under 3211G unless the plaintiff shows there's no substantial basis in law. And then 70A says if there's a determination that there's no substantial basis in law, fees are mandatory. The legislature did this deliberately to deter what it viewed as a wave of meritless defamation litigation, which was causing immense expense to defamation defendants. And I would submit that this claim here, if not frivolous, is close. This is a man who has lost 5 court decisions, although 2 were later reversed on appeal, claiming that he was defamed by an article reporting that he was sued 5 times and accurately reporting what was in those decisions. I don't see how that's not close to frivolous, if that's the standard the court is looking at, which I don't believe is the standard, but even if it is, I think this qualifies. I see my time is up. Unless the court has questions, I'll stand on the papers.
Thank you.
I don't see how it's possible to say that the case does not have a substantial basis in law. A defamation claim which is not dismissed by definition has a substantial basis in law. So it's a circular definition that's in the statute. If I bring a claim that's not subject to a motion, that's not dismissible, then by definition it has a substantial basis in law. So why are we imposing on top of that these additional requirements? What is happening here with this statute is that it is essentially immunizing newspapers against defamation suits brought by private persons. It's imposing additional obligations on them, including the threat of having a fee award against them. And, you know, clients have First Amendment rights too. Petitioning the court and seeking redress of a grievance in a court is a First Amendment issue. And the ability to pursue a claim is being hampered here, which is why the constitutional issue, I think, it has to be addressed. I really believe it should be addressed because it has upended defamation law in a way that I don't believe the legislature really intended to do, but that seems to be the effect of indeed what they have done, because it's now private persons and public figures are the same in terms of their obligation to demonstrate malice. There's ample case law in the state of New York about private people not having to specifically allege facts to show malice. They can simply say it, and whether malice exists is then a matter for discovery going forward with the case. But now suddenly everyone has to prove malice, and there's not going to be any more defamation claims, especially brought by private people who already have a hard enough time doing this. And so the definition here is circular, and it doesn't really make any sense. So I don't see how a statute has now suddenly become a license for newspapers to say whatever they want about private persons. That's really what's the issue here. Thank you.
Thank you. Thank you both. J.D. versus the Archdiocese of New York.
Good afternoon. May it please the court, I'm Jeff Herman on behalf of the appellant. We concede that the Archdiocese did not own Fordham Prep. It's not an issue here today. What we're alleging is that the Archdiocese controlled and supervised Fordham Prep, the Catholic school, and that they controlled and supervised the priest, Father O'Brien. We also allege O'Brien was an employee and an agent of the Archdiocese. The defendant...
It's an affidavit by Cassidy. Why isn't that enough?
Well, the affidavit is not considered documentary evidence. In order for the defendant to refute under 3211, they must produce documentary evidence that utterly refutes the allegations in the complaint.
So this case has, we see there are deeds that are produced, and there's an affidavit that talks about the deeds that are produced and then states that the Archdiocese was not in control of the prep or the Jesuits. Is there any firsthand information with regard to that, other than the deeds, which speak for themselves?
No, in fact, the deeds and the articles of incorporation go to the issue of ownership, which we're not alleging ownership. There is literally no evidence other than the Cassidy affidavit that even talks about control and supervision. And so this court has repeatedly said in the Johnson versus Ashley case, in the William Pickett case, that affidavits are not documentary evidence and should be ignored.
So let me ask you this. What was your good faith basis of alleging the control?
Right, so we allege in the complaint.
I know what you allege, but you have an obligation to have a good faith basis. I mean, you can allege that the sky is purple if you want, or that New York is in Russia. I'm asking you, what is your good faith basis of alleging that Fordham is controlled by the Archdiocese?
Right, well, my experience in having litigated thousands of these cases, our good faith basis is that we believe the Archdiocese will have files on Father O'Brien.
Okay, but that's one thing. You can subpoena them. My question again is, what's the good faith basis for the allegation that the Archdiocese controls Fordham?
Because Fordham is within the territorial jurisdiction of the Archdiocese of New York, they have control over the school and over all Catholic priests.
I know that's what, that's what I'm asking. Like, where do you get that from?
Well, that is the organizational structure of the Archdiocese.
I mean, there are Presbyterian churches that are within the Archdiocese. Again, I'm asking you, what is the basis of that?
Right, we're asking.
You have to do an investigation, right? You have to put in a complaint that has a good faith basis for the factual allegations. I'm just trying to figure out where you started to get that. Yes, it is. Yes, it is a Catholic organization, but where do you connect it to the Archdiocese? How did you connect it to the Archdiocese?
Right. You're asking me my good faith basis, and I'm trying to stay within the complaint. I mean, we're making those allegations which should be taken as true, but I know we know we're alleging in good faith that that is how the structure works, and that the Archbishop of New York is in control of all Catholic entities, schools, Catholic priests within his territory. He has the right to control them. If he has.
So, for example, you would say that the Archdiocese has control of Marymount or Sacred Heart.
If they're Catholic schools or churches within this territory, correct. And that is, so all Catholic churches within this territorial jurisdiction are subject to the control of the Archdiocese and ultimately the Archbishop. Now, it doesn't mean that O'Brien didn't also work for the Jesuits, which he did. Father O'Brien, in this case, he can serve two masters. He does work for the Jesuits. He worked for the Fordham Prep School, but he was also subject to the control and supervision of the Archdiocese of New York. And so the Archbishop and the Archdiocese, when they get notice that Father O'Brien is molesting children at Fordham Prep, they have the right and the duty to remove him, to tell Fordham Prep, either you remove him or we're going to shut you down. That school.
Just let me go back to what my colleague asked. Do you have documentation? I mean, are you talking about something in particular that existed in 1962 or 65 or whenever this action occurred that you're relying on?
Well, I have to stick to the complaint, you know, obviously for
right,
today's
I know
purposes,
the complaints make statements, but
right, we have a good faith basis to make the allegations.
Is it based in something? Is there something that where you derived the information that you put into the complaint?
Yes.
Yes, so that's what I'm asking.
Yes.
What is that?
Well, we know in other cases that we've
are you talking about documentation or deposition, sworn deposition? I mean, I don't know what you're speaking about. I see the allegations, but I'm not sure where they derive from. That's the question I'm asking.
Right. Well, it comes from our understanding of the way the Catholic Church operates, particularly.
That's what we're trying to find out. Like, where is that understanding from? What,
It comes
what
from-
investigation did you do?
We've done investigations for decades. We've talked to experts within the Catholic
Because you
Church.
said when the archdiocese gets notice about the abuse, you stated that as a matter of fact just now.
That's what we're alleging. We're alleging, and again, we are alleging that the Archdiocese knew or should have known that Father O'Brien was unsafe to be around children. And so, yes, that should be taken as fact by this court. The standard of review here is to accept our facts as true and give the plaintiff every benefit of inference. Now, to go back to your question, what's the basis, without getting into specific details, I'm not prepared to give you that, but for decades, we've been litigating these cases. We've talked to experts, we've talked to scholars, we've talked to witnesses, and it is our understanding.
So has the Archdiocese ever, in the decades that you've been doing this, the Archdiocese has acknowledged that it controlled or had anything to do with the hiring, firing, and moving around of Jesuits at Fordham?
I don't think the Archdiocese, I'm not talking about just this Archdiocese, I'm talking about Catholic churches across the country. You're asking me with this particular...
Yeah, I guess I'm just trying to figure out where the allegation comes from, because that's what I'm...
Let me step back then.
You're saying we should accept it as true.
Yes.
And I'm just trying to sort of probe a little bit, what's your good faith? Because you can't, again, you can say whatever you want in a pleading, but you have to have some good faith basis for saying it. And so you're saying that you've been litigating against the Archdiocese in New York for decades, and they have...
Okay, no, so let me step back, because you're asking me my basis for the allegations that we put in a complaint, and which goes beyond now the allegations in the complaint. And so...
No, your allegation is that the Archdiocese hired, fired, knew about him, moved him around, and did that. So I'm just asking, and the Archdiocese put in an affidavit that said we had nothing to do with it. So I'm asking you just what's your good faith basis for the allegation?
Okay, just to clarify, we did not allege that they hired and fired
I'm sorry. What did you
O'Brien.
allege that they had control over him?
Yes, so, and
Right?
it's...
So that's right. And they said, no, we didn't. We have nothing to do with the Jesuits at Fordham. So you're...
Their lawyers, right, their lawyer said, no, we didn't control or supervise him.
Right.
Okay, and so this court is asking for me the basis for us to allege these things. What I'm telling you is that for decades, I have been litigating Catholic Church cases. Dioceses in the United States across the country operate under the same sorts of rules and jurisdiction. And so other dioceses, and we have investigated, and the basis is that we've talked to experts who have also investigated other dioceses. There's experts who used to be our former priests who have testified. There's articles...
And so that's your good faith basis, is what you're saying?
Yeah, so
That
we have a good
investigation is your
faith
good
basis.
basis.
Okay.
And respectfully, this court should accept those as true.
Absolutely.
And it's the burden
Right.
of the defendant here to provide evidence outside of an affidavit, which they have not done. There is zero evidence, documentary evidence provided.
Thank you.
Thank you.
May it please the court. My name is Peter Johnson of Leahy and Johnson, and I represent the Archdiocese of New York. And respectfully, if I could answer the question that hadn't been answered so far. And I respectfully point to pages 201 and 202 of the record on appeal. And I quote my distinguished colleague, Mr. Herman, in relying on the canon law, the religious law, although I think he gets the wrong volume. I think it would probably be the 1917 Pio Benedictine Code of Canon Law. But he quotes religious law and says, the allegations of the complaint concerning the Archdiocese's control of Father O'Brien and Fordham Prep are consistent with the structure and hierarchy of the Catholic Church. Even if Fordham Prep and its priests, including Father O'Brien, were associated with the Jesuits' religious order, their work and services within the territory of the Archdiocese were subject to the Archdiocese plenary control. That's a canon law term.
Why isn't that a good faith basis?
Because he then quotes Canon 678 of the Code of Canon Law and says, religious are subject to the powers of bishops, who they are bound to follow.
Let me ask you this. Is there a document in the Archdiocese control that shows who the Archdiocese employs and who it doesn't? Or a series of documents?
Yeah, I mean...
So why not just put those in?
We put everything in that there was...
No, you put in a deed and an affidavit from somebody who had no idea what was going on in 1967. So again, my question to you is, are there documents that show who the Archdiocese hired, fired, and controlled? There have to be some kind of HR records.
Justice Scarpullo, may I suggest that, number one, the complaint as pled is non-justiciable because it requires...
No, we're not doing that. You made a motion to dismiss based on the fact that you didn't control this person.
Of course.
And the only issue here is, did you put in enough on your motion? And I'm asking you, aren't there documents that show who the Archdiocese paid, didn't pay, moved around? Aren't there any HR documents?
To prove a negative in
I
terms
agree,
of...
it's hard. But again,
why don't you tell us?
Answering my
why don't you tell us what you did put in?
I'd be happy to. Justice Scarpullo, let me just respectfully suggest that with regard to the property deeds, with regard to the corporate documents, with regard to the judicial admissions by Fordham Prep, by the Jesuits, with regard to control and ownership and operation, I would suggest, and the record bears it out, that Mr. Herman didn't suggest that the Archdiocese of New York owned or operated or controlled. In fact, he pled that the Jesuits controlled Fordham Prep. And so there are no records with regard to...
So why then, I'm sorry, I'm going to finish your statement.
Yes, Your Honor.
There are no records. There's testimony from different people. There are the deeds.
Correct, Your Honor.
We have, yes, but aren't the things that you have, the testimony, the statements, all of this, aren't they subject to credibility determinations? Don't they raise issues of fact that have to go before a jury and are not for us to decide?
Thank you, Your Honor. I don't believe so. And let me tell you one very important defect in this defect-laden complaint. There was no allegation with regard to specific factual allegations on control. It's in Mr. Herman's own words that somehow it's part of Code 67-8 of the canon law. And so then when I say it's non-justiciable, that requires, based on the jurisprudence of this court, the U.S. Supreme Court, the Court of Appeals, an examination of canon law, of religious law, to say, oh no, I can't show, Mr. Herman can't show, in fact, he doesn't even plead that there's a contract, that there's an agreement, that there's an employment agreement, that there's some memorandum. He just says, well, it's control, and it's based upon what I believe the Archdiocese is. And so he had an opportunity to come forward with an affidavit.
No, but that's his complaint. This is a pre-answer motion to dismiss. This is not a motion for a summary judgment. He's correct. We have to assume that that is true. So all you had to do, which you didn't do, was put in an affidavit from someone with personal knowledge that says,
Mr. Cassidy,
I have looked at all of our documents. I have looked at everything that we have. We do not control that we did not, this particular priest, we didn't hire him, we didn't fire him. There's no evidence of that. I know it's hard to prove a negative, but people do it every day.
Well, I think he said it, and Mr. Cassidy,
you didn't do it.
But he made it on personal knowledge. The
Excuse me?
affidavit is based on personal knowledge, Judge Scarpula.
You're saying he knew what was going on in 1967. He didn't even get hired until 2003.
He's now-
I don't know what personal knowledge he could have
Personal
had.
knowledge is based upon the books and records of the
So
corporation.
then put them in. That's the whole
but
point.
you-
You
but-
can't just accept his statement without putting in the information,
There-
which is why I keep asking everybody,
There's a
what are the
larger issue,
bases
Judge.
of these statements?
Let's hear what he has to say.
There's a larger issue, and it's been ignored by Mr. Herman in his brief. The issue is the non-justiciability of this issue. This complaint is premised entirely on the canon law of the Catholic Church. And so now is the Catholic Church in the Archdiocese of New York to be held to account? Is civil law and canon law the same thing? Is canon law and
Those
civil
sound
law?
like issues that are going to be determined at a trial with experts who are going to be speaking to those issues, because I don't see a number of affidavits from experts that go unchallenged in these documents.
But respectfully, I disagree. There is no right to put before this court and to say to you, Justice Renwick, and the other distinguished members, and Justice Friedman, I need to consult the canon law to determine what the control is. If there was an issue involving the Muslim...
You don't have to consult the canon law. That's their good faith basis for bringing these claims. You just have to have something that contradicts it.
But I would
And
say...
if you don't have it...
The court below determined that it was an absolutely feigned issue. And we've had two judges with de novo reviews, Judge Silver...
Well, we have 5 judges
Justice
here,
Love.
so we'll make a determination as to whether we see that or not. But for now, you're here, you have an opportunity to tell us why you have presented documentary evidence that ends this dispute. And what I see in the record are a number of deeds that speak to who owns property. And I don't think that's challenged. But the question is whether or not there's any supervision or control over this individual, any supervision or control.
None. And under Rovello, we have the absolute right to submit an affidavit. And the fallacy and the misdirection of the brief that's been submitted by the plaintiff here is that the court below, 2 courts below, relied on an affidavit from Mr. Cassidy when they made it clear that they relied on the documentary evidence that the Jesuits were independent and that there was no control by the Archdiocese. That is further borne out by authoritative statements and evidence based on judicial admissions. The telling informal judicial admission is that today, and in his earlier opposition to our motion, Mr. Herman proudly bragged that this is based on religious law. I would suggest, and I have some experience in these issues, I'm not trying to put that before the court the way that the court heard this afternoon, that I will rely on my experience. When he had an opportunity to put forward an affidavit, he failed. When he had an opportunity to put forward some information, he failed. When he had an opportunity to plead a contract, he failed. No contract issue is religious control. So in his mind, religious control means civil liability. That's not in the religious corporation law. That's not in any statute I know. If he's litigated hundreds of these cases or thousands of these cases, certainly not against me in the Archdiocese, why didn't he come forward with some information with regard to this other than asserting religious law, which is patently and blatantly unconstitutional and is a violation of the precepts from the Court of Appeals to the United States Supreme Court? This needs to be decided on neutral principles. And I would conclude by saying that we have laid out not only the documentary evidence, but the judicial admissions that made clear this court is not about deciding Catholic law, Jewish law, Muslim law, the law of any religion at all. And what Mr. Herman is suggesting today is that I know about religious law, I've quoted canon law, got the wrong canon law, and the court should adopt that as a basis. That's not a good faith basis. That's an unconstitutional basis. This is not a justiciable controversy. He failed to state a cause of action. Even
Thank
if he
you.
did, we dismissed it on documentary evidence. And I thank the court for its time here today. I appreciate it very much.
Thank you.
Thank you. It's not my job to submit an affidavit. I mean, and I'm not citing religious law. But I want to make clear this whole First Amendment issue because I think it's a red herring. We're not asking the court to determine how church organization or to tell the church how it should run itself. What the court can do is examine how the church does run itself using neutral principles of law. That is the sex abuse law in New York. There is nothing unconstitutional about the court looking at all the laws, all the policies and procedures that the church operates under and say, yes, you have the right to control this priest, even though he's a Jesuit. And if you had knowledge that he was molesting kids, you were negligent by not exercising your right to remove him. Those are neutral principles of law. And so we're not suggesting, we respect the right to religion, the right to believe any religion what they want. It is simply a red herring. We did cite to this article, and I thank you for reminding me of that. In the brief, it was this article which talked about, in our brief, rights and responsibilities between dioceses and religious communities, which simply talks about the fact that there are situations in a territory of a diocese where there's a religious order and in a diocese where they overlap. This Catholic school is one such example. And in those situations, we are alleging that both the religious order and the archdiocese have the right to supervise and control certain things taking place, in this case, predator priests molesting children. That's what we've alleged.
Where would the archdiocese's right to do that come from?
I believe it comes, well, there may be, we don't know if there's a contract. Typically, this article talks about, because of the overlap, there are contracts. We don't know if there is one. There typically, according to this article, there would be contracts outlining their rights and responsibilities. We believe there's probably files of communication between them. We know that historically, when priests from orders come into a diocese, they get permission, and there's communication. There is certainly canon law that would apply. Well, we're not asking the court to create canon law. We're asking the court to examine whatever laws are in place already. That is not a violation of the First Amendment. The courts do that all the time, being mindful of not getting into church doctrine. And we're not asking the court to do that. The bottom line is, if I could summarize, we've met our burden of alleging a valid negligence complaint. The defendant has failed in their burden to submit documentary evidence that rebuts that. They could have, they didn't. This case respectfully should be reversed, remanded.
Thank you. Thank you both. Cassin Sabah Realty against 125th Street Holding.
Good afternoon, Your Honors.
Good afternoon.
May it please the court. I'm Claude Castro for the appellant, 125th Street Bapaz, LLC. We are seeking an order reversing the trial court's decision which denied our motion to dismiss a brokerage claim. The facts are straightforward. The complaint alleges clearly that the broker referred our client to a property which he was told was being sold by a seller. He was given a setup which said the seller was selling the property at a given price. My client told him that he would not meet the purchase price.
So we know the facts, and we know that there was a meeting, and there's at least testimony in the transcript from the depositions that the seller's broker may have intimated something, may have made a statement about assignment, and then later on said he didn't assign it. But the question is here, whether or not the plaintiff broker is the procuring cause
Correct.
of this ultimate assignment,
That's
in which
correct.
the defendant purchased the property.
Familiar-
And my question
I'm sorry.
is, aren't there issues of fact here based on this record that suggest that there are?
No, Your Honor. And before I get to that, let me just step back. The complaint, which was amended, verified complaint amended, in both versions says that the plaintiff referred the client to the seller to buy the property from the seller. He never says anywhere in the complaint, even after it was amended, that he was there for an assignment. And I submit, as a matter of law, that is a judicial admission.
Well, at that point, everybody knew that there was a contract. There was already a contract between the seller and the third party. So there wasn't going to be any sale. It had to have been an assignment, some sort of purchase from the third party, right?
No, Your Honor. My client was brought to that meeting at 9 o'clock at night at a hotel with the understanding that he was negotiating a purchase from the seller. It was only at that meeting for the first time.
Okay,
he finds
yes.
out, and then he walks away. And bear in mind, Your Honor, the buyer of the contract, under that contract, was not present.
But isn't there a question as to whether or not there were discussions that evening at the hotel about an assignment?
No, Your Honor. You read
There
their
are no
brief.
questions about that?
Your Honor, if you read their brief, they say that the discussion was an assignment of the seller's contract to my client. Now, think about that. The seller of a property could not assign that contract to my client. What would he do? Assign him the right to sell a property that he's looking to buy? A property that he doesn't even own? Your Honor, and beyond that, you have the case that you affirmed, where Judge Schechter ruled below. Very similar case. Someone is referred to a buyer, he makes an offer, it's rejected, and then months later, they take an assignment from a separate broker, and they close. They sued, Your Honor, on the same theory. They said, well, we introduced you to the property, and Judge Schechter said, but you had nothing to do with the negotiation of the assignment. Because what my client did...
Except here, this is what I keep going back to, it's not completely clear as to what happened at that meeting, when they went, or why it was brought up in the first place, because the broker said, I told him that somebody else made an offer already.
Okay.
So there's a question as to why they had the meeting anyway, and whether or not assignment was raised at that.
Your Honor, I don't know why the meeting was scheduled, because you don't schedule a meeting with a buyer, with a seller, rather.
Well, if you don't know why the meeting was scheduled, that seems to be a big question to me already. There are issues here that
Your Honor,
someone needs to know the answer to.
Why the meeting was scheduled. The fact of the matter is, at that meeting, the seller was under contract. He could not sell the property to my client. My client made an offer. It was rejected. He left. That's the end of it.
Now, there's testimony that the purpose of the meeting was to discuss the assignment.
No, my client did not even know there was a contract when he went to the meeting. And if you look at their brief, Your Honor, they don't tell you that the broker themselves were aware that the seller had a contract.
Well, record 234, 235, 236, 237, 247, 248, 249, 250, 51, 56, 57, 255. These are all pages on the record, 189, where they discuss somehow that the purpose of this meeting was to talk about a possible assignment of the contract.
Let's assume that's true, Your Honor.
I don't know if it was.
Right,
That's what
let's
Judge
assume.
Raybould is saying.
For the
There's
purpose
an issue as to whether or not this is true.
Let me take it a step further. Let's assume that's true. There was a discussion about an assignment. The buyer, who's the only one that could have assigned the contract, was not present. There was no agreement reached at that meeting with the buyer to assign the contract. Nothing. Everybody walked away. Nothing was agreed upon. It wasn't until 3 months later, Your Honor, when a new broker that we never knew, he came to us and he said to us, by the way, the buyer of this contract is interested to assign this deal. And what my client did at that point, things had changed. He had a 1031 exchange, and he agreed to, and the deal that was negotiated by the other broker, Your Honor, was not just to take an assignment of a contract at the purchase price, but my client had to pay an assignment fee of $550,000 in addition to the purchase price. So in other words, the deal was brokered by another broker. He brought about a meeting of the mind between not the seller and my client, but between the buyer and my client on an assignment. That broker had nothing to do with it. He didn't even know it was taking place. So, to answer your question, Your Honor, there may have been a discussion, but this court has said many, many times, SPRE and many other cases, mere introduction is not enough. Mere discussion is not enough. You have to bring a meeting of the minds together. I asked counsel, what did this broker do to bring about a meeting of the mind between the buyer and my client 3 months later?
Now, was the price that was agreed ultimately something very similar to what was being proposed?
Your Honor.
Prior to the meeting and even possibly at this meeting?
No. Your Honor, we were told the seller was looking for $13 million. My client offered $12 million. The broker said, I'll bring you to a meeting, let's see if we can bridge the gap. My client goes there to buy from the seller. The seller tells him, I will not sell for less than $13 million. Then he finds out he's in contract at 12.9. Okay? Now, 3 months later, my client takes an assignment of the contract. The price is locked in. There's no negotiation with the seller. He's in contract. My client takes that contract at the frozen price of $12,900,000, which was negotiated between the seller and the buyer via another broker, not this broker. Another broker did that transaction. And then 3 months later, after they abandoned the transaction, we never heard back from them at all. They never came back to us and said, by the way, do you want to take an assignment at X? They didn't give us a proposal for an assignment. They never spoke to the buyer. The buyer had his own broker. So it wasn't until 3 months later, through another broker, they come to us with a brand new deal that's then negotiated. And Your Honor, where the judge below said we were trying to cut across, the commission, first of all, we had no agreement with them. We didn't even know, even if we went for the deal, what were we going to pay them? There was no agreement. But my client agreed to take the assignment of the contract as is, paid an additional $550,000 as an assignment fee via an agreement made with the buyer that they had nothing to do with, and he paid his broker. The seller paid his broker. It's not like somebody cut out a broker here, Judge.
Thank you.
Thank you, Your Honor.
Good afternoon, Your Honors. James Andriola on behalf of the respondent, Casson Sabag Realty, LLC.
So how is your client the procuring cause of the buyer's
So the
assignment?
entirety, as the trial court found, at the meeting, all the pieces were in place, I think the trial court. All the pieces of the ultimate transactional construct were known to each other, present and accounted for.
The buyer's broker was at that meeting, correct?
Yes. That's why he keeps saying that the buyer wasn't represented at that meeting. The trial court noted, and the buyer's broker testified, the only witness in the case and a non-party, that his clients were the purchaser, and he was at that meeting.
And doesn't he actually say something about an assignment, and then later on in that transcript you're talking about, he says, no, I don't think so?
Mr. Safdie was the only witness who testified because of when they filed for summary judgment early in the case. He testified that the only reason you could even have had the meeting on March 28th was an assignment of the contract that was entered into in earlier March. And he even says, and at 2:35, it starts his quote, and he talks about Mr. Nass telling him why there was going to be this meeting. Now, Mr. Nass is the owner, he's the owner of the entity that owned the property.
You come into the picture at the outset in order to try to broker a deal between the seller and the defendant, and you're not able to, right? That's you're trying to get that property bought by the defendant.
So the initial contact, my client made his client aware that the property existed and was for sale, which contradicts.
$13 million, there's some negotiation, you say it's got to be at least $13 million, and nothing's happening with that deal.
So in November, my client contacts his client, says this property's for sale. There's a lot of back and forth over the next couple months where his client has interest in that. Then in March, it goes to another level after there's a contract in hand.
But nothing happens of that, right?
Well, no, they go to a meeting.
In November, it leads nowhere.
They go to a meeting and they says, if you can pay $13 million, I have a contract in hand that can be assigned to you. And lo and behold, within less than 60 days, that contract in hand is assigned to his client, and my client gets nothing, even though they procured that meeting, but all the people that had to be at that table, at the table. And the trial court did a comprehensive analysis of the facts and found that.
But it had nothing to do with that deal that's getting assigned,
Yes.
right? It had nothing to do with that. It was, you were trying to sell the property, and you're unable to. Someone else buys it.
No, at the March 28th meeting, what existed was a contract. My client set up that meeting to discuss a potential assignment of that contract.
But you had nothing to do with, because you had been trying to sell it to the defendants, and you don't succeed in making that deal. Someone else comes along and buys the property.
Well, my client brought everybody together.
Is that what happened?
And then they go behind my client's back and
this
take the
right?
exact assignment.
Is this
Sorry.
right or wrong? You're trying to broker a deal in which the defendant buys the property, right?
Initially,
It's
yes.
November.
Then try to broker a deal where he
Just a
takes an
second.
assignment.
Counsel, just wait till the court asks the question.
That doesn't come to fruition. Instead, someone else buys the property.
Someone else takes an assignment.
Not an assignment. Someone else enters into a contract to buy the property from the seller, which you have nothing to do with.
That contract already existed before the March 28th meeting.
But it didn't exist in November when you're trying to make the deal. So yes, it exists at the March meeting, but you had nothing to do with that contract coming into existence.
No, then that's not the allegation.
Did you know when you were going into the meeting that there was an assignment? I'm sorry, that there was a contract of purchase?
The testimony from my client is that the
Did your
assignment
client
of
know?
contract, I wasn't at the meeting, but.
No, I meant, did your client know?
Yeah, they testified that the assignment of contract was discussed at the meeting.
My question is, did they know going into the meeting? Did the broker or the ultimate buyer here know going into the meeting that there was a contract of sale pending?
I don't want to misquote him.
Well, while you're looking.
Oh, this is his exact language. Quote, either prior to or at the meeting itself, I came to learn that Robert Nass had entered into a contract to sell the property to a third-party purchaser.
So it's unclear whether it was before or during the meeting, which might make some difference here. But at the meeting, Mr. Sadie, he was the broker for the
purchaser.
The purchaser, right? And he says at one point, he answers yeah to a question of, but it all focused on an assignment of an existing contract as opposed to a separate transaction, correct, in your mind? He says yeah.
Yeah, I remember asking that question.
That's, okay, so you're asking the question, but he's giving the answer. That's what he says, yeah, which is, it's related to an assignment.
Yep.
And then later on, he says that he didn't recall the discussions involving the assignment. So there are two different answers to the same question, potentially, about what is going on here with regard to this assignment.
That's the one non-party witness that we have so far, and even he contradicted himself on the issue of. So I think as you started off the initial question, it smacks of an issue of fact.
I don't know that it makes a difference, but what we don't have here is that someone went around you and bought the property without paying a brokerage. They paid a different broker. Isn't that what's happened here?
Well, yeah, yes.
And you're saying you shouldn't have paid that broker, you should have paid me.
Yes, not me personally, but my client, yes, because we brought them together.
Right, I understand
Yes.
that you personally, that
And they're-
you're the broker. So how are you the procuring cause of that, of the deal?
We brought all the four parties to the table to
You
discuss.
don't reach an agreement on price at that point.
Well, the gentleman said, I have a contract in hand for $13 million. And that's the contract that they ultimately took an assignment of.
It doesn't even mean that that's what they paid. They may have had to pay additional funds in order to get that contract to the Asanua, right?
Yes,
We
but
don't
the contract price was the
We don't know that
same.
that's the price. I mean, actually, as a matter of real estate practice, it's hard to think that the Asanua really just turned over this contract, which was for $13 million, without making something on it.
No, no,
I mean, they flipped the deal in effect, and usually when you flip a deal, you look to make money on it.
yes, and that's what Mr. Softy even said, the reason for the meeting was they have an existing contract, but both the seller and your buyers can make a little extra money if maybe we can flip the deal.
But at the end of the day, you didn't bring about an agreement not as to price for this property.
Well, I would respectfully submit that we procured.
And what do you mean you procured? What did you actually do?
We introduced Mr. Israeli to the property. He told us that since we introduced it to him, he wanted to work exclusively with us. Again, I'm using us, my client. We set up the meeting at which time the $13 million existing contract existed, an assignment of that was discussed.
This case is not based on the fact that you have an exclusive.
No, no.
And there were discussions at the meeting with regard to assignment?
Yes, and that's my client, Mr. Safdie, and then even Mr. Israeli, his client says, the guy kept telling me I have a $13 million contract in hand.
Your time is up. Thank you very much.
If I might just address a couple of points. Judge Rodriguez, the buyer's broker was present, but he wasn't a lawyer for the buyer. He didn't have power of attorney. He had no right to bind the buyer to anything at that meeting. He was there to listen. This is what the seller said. He was there to listen. And he said, when asked at his deposition, was there a discussion of an assignment? He said, there may have been, but it would only be if my client decided not to go through with the deal. The buyer was never there at that meeting. The buyer never said, yes, I'm interested in an assignment. He's the only one that could say whether or not he would be interested in an assignment, not his broker, and certainly not the seller. The seller has no right to assign anything. But to get back to the issue of procuring cause, you're right, Your Honor, this was a flip. And on a flip, you negotiate how much are you going to pay over the purchase price. And this is what this other broker that came to us 3 months later, my client didn't pursue the property. This broker came to him, and then they went ahead and negotiated, not with the seller, but with the buyer, to pay him a $550,000 fee for the assignment. They had nothing to do with it. And again, Your Honor,
You didn't pay $13 million for the property, you paid $13,500,000.
Exactly. And when the court below says,
they had nothing to do with the deal that reached the $13,500,000 price.
Correct. Absolutely nothing. And I think Your Honor hit it on the head, because no matter how we turn this, they were not the procuring cause of the assignment. And I refer this court to the judge that, by Judge Schechter, that this court affirmed. Same thing, Thor Properties made a bid of 86.
That meeting never even branched out to discuss what the fee might be for an assignment.
Correct.
It was just a $13 million price.
Correct. And nobody agreed to anything. They left, and we didn't hear from them for 3 months, Your Honor. They didn't pursue it. So how could they be the procuring cause of anything? Thank you, Your Honor.
Thank you.
Have a
Thank you
wonderful
both.
afternoon.
McCabe versus 511 West 232nd Street.
Good afternoon, Your Honors. For the appellant, Marion McCabe, Vernon and Ginsburg by Yoram Salagi, such an honor and privilege to argue before this court. Your Honors, the appellant, Ms. McCabe and Mr. Burrows, they were together for 27 years as a couple. They lived for 13 years in the co-op unit at issue together. That fact is undisputed. While
But they
Mr.
weren't, you're right, but was she, according to the bylaws, was she his spouse or was she a family member?
Your Honor, she was the equivalent of a spouse. She was
How do
his
we know that from this record?
Because, Your Honor, we've submitted evidence of the fact that she was a romantic partner of
But where
Mr.
does it,
Burroughs.
in other words, where does it say that? How do we know that? We have a will where she's described by the decedent as a friend. It doesn't
Yes.
say, I mean, best are his words, and there are no words of his here that say she's a spouse, she's a common law spouse, I intended to marry her. It says friend. Sounds very platonic.
Well, Your Honor, first, she was also on the healthcare proxy.
Also
And
as a friend, by the
Yeah,
way.
we can't read someone who's deceased, we can't read his mind as what someone would call him in a will. My guess is, Your Honor, it's because, for purposes of estate plannings, when you leave for genetic family members, you don't want to, press on their rights by calling her something else, but it's really not relevant for purposes of this case, Your Honor, because the overwhelming evidence, which is undisputed, shows they were romantic partners.
But
and that's
isn't
not
it-
really, that can't be disputed. There were obituaries, Your Honor, before this issue even came up. There were obituaries of Miss McCabe's parents from years
So the
before,
bylaws,
which called her a
I'm going to say
lifetime
something now.
companion.
You're
I'm
going
sorry,
to
Your Honor.
stop for a moment. Thank you. So the bylaws indicate that the state, that the person has to be a spouse, a wife, or I'm not sure if they use that word, but a spouse, and then, or a family member. And if it's not one of those two, then it really is to the sole discretion of the co-op. So without documentation here to clearly indicate that, what do we do? Especially since at some point before the decedent passed, there was a letter that was sent to the co-op board, and the lawyer responded asking for documentation that showed that this was the spouse or the partner. Nothing ever came back with regard to those issues. Nothing came back saying, look, here's XYZ, or I don't know if he was able to respond himself at that time, but he was still alive. We don't even know. There's nothing there.
The answer, Your Honor, is the co-op, they didn't want to resolve this case. They asked for a marriage certificate or a domestic partnership certificate, and they knew they didn't, that we had neither.
You're right, but was there any other response, like a statement from
Yes.
the individual who owned the property?
I wrote on their behalf, Your Honor, at least 2 letters showing their relationship and giving.
I understand, but he was still alive before, when that letter came, he was
Right.
still alive.
Yes.
There could have been an affidavit or something from him saying, we're not legally married, but I am bound to her in common law. She's my common law wife, or something to that effect.
No, Your Honor, because they weren't, Your Honor, their conduct in this case, they weren't interested in settling. They just wanted a marriage certificate or a domestic partnership certificate.
But
They
you
were
didn't
not
offer
interested
the
in-
other.
They were not, we didn't have those documents. They weren't interested in resolving it by any other means. They knew they were romantic partners. And the answer to the other part of Your Honor's question is based on that clause in the lease that allows transfer to a spouse without the co-op's consent. This court has held in David v. Morse that city, state, and federal discrimination laws say that once you have clauses like that, that it protects couples and domestic partners. So this couple here, Mr. Burroughs and Mrs. McCabe, pursuant to this court's ruling in Morse v. Fidessa, it protects them as a couple and a partner. And the lower court erred in relying on the Court of Appeals ruling in Levin, which, as this court stated in the Morse ruling, was overruled by legislation. This court specifically stated, and I'll just read very quickly from Morse v. Fidessa, the narrow definition in Levin of marital status for city human rights law purposes was legislatively overruled, providing city HRL protection for couples on the basis of whether or not they are married to one another involves an entirely plausible interpretation of marital status and encompassing couples protection within the prescription against discrimination on the basis of marital status.
Does it matter that the Morse case involved an employment discrimination case?
No, it doesn't, Your Honor. All these cases are different facts, but they specifically stated in that case that it encompasses couple protection and that the marital discrimination protection and couples protection, they're to be liberally interpreted.
Thank you.
Thank you, Your Honors.
Good afternoon, Your Honors. Michelle Quinn of Gallant, Dreyer, and Berkey for the respondent. May it
Counsel,
please-
yeah, good
May
afternoon.
it please the court.
There are suggestions everywhere here that they were lifelong partners, or at least for the last 13 years. Why shouldn't we interpret this liberally to find that they did have a marital status that the co-op should take into consideration?
Because the appellant is not a spouse. The issue here is the terminology utilized in the proprietary lease, which affords considerations to someone who is a spouse. A spouse has a very specific meaning as set forth in the domestic relations law and in the IRS, and even in criminal defense where you can invoke a spousal privilege, not a marital status privilege, in not testifying against your spouse. It's a very specific term.
And are you, when we're talking here about transfer of shares,
Yes.
right? And so like any other corporation, a small corporation, one can say, I will only allow you to transfer your shares to this person and this person and this person without a financial review or anything like that. And that's been upheld in all kinds of contexts,
Yes.
correct?
Yes. So what we're saying is the cooperative did not discriminate against Mary Ann McCabe because of her marital status as single common law marriage, which doesn't exist in New York, or otherwise. What the cooperative did was apply a lease category to her request to transfer the shares. She said, I'd like to get the shares. We said, are you a spouse or a domestic partner? She came forward with no evidence of either, and therefore the analysis of her request to transfer shares as a spouse was not going to be fulfilled. We could then try to determine her application based on her family member status. But even there, she did not qualify because, number one, she didn't actually demonstrate that she was a family member with any objective proof. Counsel saying, or Ms. McCabe's subjective description of their loving relationship or saying the co-op knew that they were romantic partners isn't evidence. In fact, I would submit that Ms. McCabe's submission of her obituaries of her parents is subjective. Presumably, she wrote the obituaries. There's nothing, as Your Honor recognized, from Mr. Burroughs, which stated, Ms. McCabe is my wife. I view her as my wife. He, in fact, said, I view her as my friend. And that then takes out of the equation transferring the shares to her without board consent as a spouse. Appellant is not a spouse.
Are you saying that before he passed, he could have done an affidavit that says, she is my family member in all ways, shape, and form, and that would have elevated her to a different status under the proprietary lease? It wouldn't have, she couldn't have, I understand they couldn't have passed the shares to her without, but that, there were like 3 different levels, right? It was spouse, which you don't have to do anything for, family member, which is a less of a review, and then everybody else, which is show me your finances. So are you suggesting that if that had happened prior to his death, if he had put in objective evidence, let me show you that she is my family member this way, and this way, that might have changed the result?
It would not have changed the result because even as a family member, even if he had said she's my family member, her financial status was not supported. In fact, in the record, she states that she has a net worth of over $600,000, but she incorrectly calculates the mortgage. In her assets, it's on page, one second. Pages 343 and 344 of the record, where it states the assets and liabilities. She double counts. She counts the mortgage payments that she made for each apartment, in addition to the value of the apartments as an asset. The mortgage payments you made is money that's spent. It's not an asset. You can't then also add to that the estimated value of the apartment. So that's double counting.
So here, the shares will automatically pass only if she's shown to be a spouse, and in order to do that, you had to show a marriage certificate.
Marriage certificate or domestic partnership certificate. There was no impediment to them getting married. He describes, as counsel says, they were supposedly together for 33 years. The will and the healthcare proxy were executed at least 5 years prior to his death. So at that time, they, according to their own testimony, they were together for 17 years. So he should have, you would think, describe her differently in those documents, especially since she is already a shareholder in the building. So she knows the terminology and the requirements of the proprietary lease. And in fact, her discrimination allegation is undermined by the fact that she's also a shareholder because she's a female, she is single, and she's an owner in the co-op. So there is no discrimination here, as the lower court found. The appellant is not a spouse, and that is the issue. Thank you, Your Honors.
Thank you.
Unless you have any other questions.
No.
Thank you.
I can't emphasize more clearly that she was his lifetime companion. Who leaves their co-op shares to just a friend? The co-op shares were respectfully left in the will to the person he was living with for 13 years. The co-op did not dispute that they were living in the unit together for 13 years, and it's undisputed. We have documentation that she's taking care of him in the apartment while he was undergoing hospice care. The obituaries of her parents, which were done way before years before this issue even arose, referred to Miss McCabe as Mr. Burroughs' lifetime companion.
Who wrote those obituaries? Who wrote those obituaries?
I'm sorry, Your Honor.
Who wrote those obituaries?
The press wrote the obituaries.
Who gave the press the information?
We don't know. It's not in the record. But, Your Honor, it doesn't matter because there was no reason to lie about that years before this issue even came up before the court. It wasn't even an issue.
The situation just doesn't fit within the clear conditions of the lease.
It does, Your Honor, because once the co-op put in that provision that says you don't need approval for a spouse, then the discrimination laws kicked in. That's why we have discrimination laws.
But we have to have a spouse.
Your Honor, as a couple, they're protected because that clause is in there, they can't treat a husband and a wife differently than a couple.
But wouldn't the best evidence here be his will? I don't understand why, under this circumstance, someone wouldn't look right to the will where he speaks in his own voice. He says, friend.
It is great evidence, Your Honor, because he left her his co-op unit for the woman he was living with. What could be clearer, Your Honor? And I just want to add finally.
But that's what I don't understand. There's no discrimination. She got the shares.
No.
There's no problem. She got the shares. It's a question of who gets to be a shareholder and live in the apartment. And
it's a huge problem.
I think that is
respectfully,
a different issue, right?
It's a huge problem. They're in housing court now trying to throw her out on the street from her home of 13 years.
She has another apartment right next door.
No, she's selling that apartment, Your Honor.
Her second, the one her son is in?
Yes, in retaliation for her asserting her rights under the discrimination laws here, they brought a housing court case evicting
Anyway, this
the
is
son.
DeHore's the record. I didn't see it in the record, so thank you very much.
Your Honor,
Thank you
just
both.
if I can make one other quick point.
As long as it's not, as long as it's something in the record.
Sure. On the family member issue, our position is that she shouldn't have been had to submit an application as a family member, that she should have been treated as a spouse. But even if she was treated as a family member, they should have approved her application. We cited an appellate division case where this court has held there's a lesser standard for family members. And contrary to my colleague's statements, her financials were solid. She was approved for her adjoining unit.
Thank you, counsel.
Thank you, Your Honor. Thank you for hearing me.
Sure. Thank you both. 129 McDougal Street versus the Tax Commission.
Good afternoon, Your Honors. May it please the Court, David Arenstam for the appellant. The appellant is appealing the dismissal of its tax certiorari proceeding for the tax years 2004-2005 against the City of New York.
So there is a stipulation here. What were your client's obligations under the stipulation?
Your Honor, my client had two main obligations. One was to file financial information on or before September 14th, 2009, that they did. And then they had to file a note of issue on or before September 14th, 2019, which they did.
Didn't they also, I mean, wasn't the reason they got this stipulation, which was to extend their time to file the note of issue, wasn't the other part of the stipulation that we'll give you the extension, but you have to come up with all the other financial statements for all the other petitions that existed?
Yes, Your Honor.
And did they do that? Did they come up with all the other financial statements?
Your Honor, they came up with
those petitions.
They came up with
Plenty of them.
They came up with a lot of financial.
But not all of them.
The wording of the stipulation is that you only have to supply financial information for a tax year that is outstanding. The way this decision works is it's asking my client to supply information for a tax year 2006-2007, which they've abandoned, which they're not proceeding with.
But did it say that in this? I mean, a stipulation is an agreement that you're bound by. And so the stipulation seems to be pretty clear in what it says. If there's a petition outstanding, and you're saying there was a petition outstanding, it says certified statements of income expenses have to be produced for those tax years also.
Your Honor, by the time we got to court, those petitions had been abandoned. The petitioner had failed to file the necessary documents to...
Was that the, I'm sorry, was that the case by the time the date came around? The date of the stipulation?
No, Your Honor. At that time, there were a whole bunch of petitions outstanding. But this, the court below said that the information was missing from the audit report from the financial statement. They didn't specify why. The city, the tax commission said, oh, information for 2006, 2007 was missing when we're only proceeding on the tax year 2004, 2005. I submit, Your Honor, that the waiver argument is very important, that Uniform Rule 202.60 gives the respondent 60 days to audit the financial information, and that rule is very clear that if they don't exercise that right, they've waived the right to question the financial information. They waited 12 years after the financial information was submitted to move to say it was incomplete. The Court of Appeals in Harris v. Niagara Falls Board of Education is very clear that if you're going to move on a technicality, you need to do so promptly, and that 12 years would be a waiver of that.
Well, would they have been able to say anything until you filed your note of issue? Maybe they thought you abandoned it. You did nothing for years. You filed a note of issue in 2019, and that's when they said, oh, you didn't file, right? So why weren't they entitled to assume that you abandoned it between 2009 and 2019?
Yana, we were in court many, many times prior to 2019.
On the
It was
2004,
on the
2005 year?
It was on the calendar many, many times prior to 2019.
So then why didn't you tell the city all those many, many, many times, oh, by the way, we are abandoning 2006, 2007, let's do a step, taking that out of our agreement?
Yana, we had decided that we were
Did you tell them that you had abandoned 2006, 2007 in any document?
No, but according to the city's position...
I'm just asking you, is there a document that says that?
No, Yana, there's no document that says that.
So it's just your assertion now that you had abandoned it?
Well, by the time they made the motion, it was clear that they were abandoned. There was no way we could proceed on those petitions, Yana, because there was no compliance with real property tax law, Article 7, and the stipulation. It was clear that we couldn't proceed and we weren't going to win on those issues. So we were just...
Why wasn't it clear that, I don't understand that, but why isn't it clear that you abandoned it by not filing any note of issue for 10 years? And not saying anything about it for 10 years?
Yana...
They're supposed to look at your records and decide that you've abandoned something?
Yana, we were entitled to file the stipulation on September 14, 2019.
You're telling me that they should have known that you were abandoned it because you were in court a lot for the 10 years. And I'm trying to figure out how they were supposed to know that without you telling them that for 10 years.
I'm going to let you answer that on rebuttal.
Yeah.
Thank you.
May it please the court, Stephen Treditti for respondents. This case turns on the simple fact that petitioner failed to comply with the RPTL 718 stipulation, and therefore their claim was conclusively deemed abandoned and dismissed as of September 14th, 2009. And that phrase, conclusively deemed abandoned and dismissed, is extremely important in this case. It is found in the stipulation, which is at pages 48 through 50 of the record, and it's mirroring the explicit language from RPTL 718, which also calls for conclusive abandonment and dismissal when a petitioner doesn't follow the requirements under RPTL 718 or under the stipulation here. And it's clear that their audit report form was not complete. As a lower court held, petitioner's claim of completeness just flatly and contradicted the record here. And you can look at that audit report form on pages 51 through 60 of the record. Petitioner also makes a number of arguments about waiver, which are inapplicable here. Because petitioner failed to comply with the stipulation, their claims were dismissed as a matter of law, abandoned as a matter of law on that date. They had an open tax year, 2006, 2007. They were required to provide the information for that tax year. They agreed.
And they didn't. You're saying, your position is that they did not abide by the stipulation because they didn't provide those.
Correct. And the audit report form is very clear. The 2005 calendar year is not listed on the income and expense statement.
Does the record suggest any reason why a tax claim involving 2005, 2006, there's an agreement to put it off until 2019?
This is standard practice in the area.
Certiorari?
In this tax certiorari, exactly. There are a number of these steps that happen all the time. This is a form stipulation that petitioner entered into with the respondents. In exchange for extending that time period by 10 years, petitioner needs to provide the city with the information for all the open tax years.
So that you can make a determination about one that might be further ahead or something to that
Correct, Your
degree,
Honor.
I
And all
imagine.
of these tax years are litigated together. This is not one separate case. And there were 8 open tax years here. And if you look at the record, page 24, there's a chart signaling why each one was dismissed and for different reasons. And the respondents submit that it's petitioner's burden to make sure that each and every one of those tax years is not abandoned. And in this case, the city, many years later, had to determine why each case was abandoned and then move to the court. And quite simply, the city should never have even had to move in this case, since they were abandoned. In this case, the 2004-2005 tax year was abandoned as of September 14th, 2009.
Thank you.
Thank you.
Your Honor, if, as counsel says, the petition was abandoned in 2009, then I don't see what difference it makes whether my client told them or not. So we had the right to file the note of issue in 2019. Also, we dispute that the audit report form is incomplete. A reading of that form shows that it has financial information from 2004 through 2007. And on a motion to dismiss under 3211, my client should have been given the benefit of every favorable inference. Thank you, Your Honor.
Thank you. Thank you both. Majuk versus New York County DA's office. You may begin.
Good afternoon, Your Honors, and may it please the Court. My name is Madeline Gilmain. I represent the New York County District Attorney's Office in this case, which is the appellant in this Article 78 proceeding.
So no one else is here on the other side. I just want to ask you, is it your argument that since the other party is not challenging this, they don't challenge that it's moot, you want to vacate it because you're concerned about the decision below, which is sort of doesn't consider the secrecy the concerns that the district attorney has with regard to the way it has to treat grand jury testimony under the statute.
That's generally correct, Your Honor. We brought this appeal not only to prevent the improper disclosure of certain grand jury materials in this case, and I appreciate that those materials are no longer being requested by the petitioner, but because
I'm trying to move you on because I gave you 2 minutes. So
thank you. And
If we vacated the decision of Supreme Court, it would have no precedential value. Isn't that correct?
that is the hope, although I will point out that the same judge who issued this decision has already cited to this case. But nevertheless,
well, after this decision, if, as my colleague just said, if we vacate it, there is nothing else for a judge to cite then.
that is correct. And I would ask that not only the judgment in this case be vacated in that order reversed, but also the underlying orders. There were 3 decisions by the court that all cited what we argue is the same incorrect rule as to grand jury secrecy. And because grand jury secrecy is of such importance to our office, it's important that a decision like that not be allowed to stand if we can't have it reviewed by this court for mootness reasons. Unless there's other questions.
Thank you.
Thank you.
One coming up.